The fluorescent lights in the courtroom hummed at a frequency I had memorized over the past 3 hours. I kept my hands flat on the table in front of me, fingers spread, the way my mother used to press flowers between the pages of heavy books. Deliberate, patient, waiting for something to become permanent. My stepfather's attorney was speaking again. Her name was Patricia Holt, and she wore confidence like a second blazer, layered, expensive, and slightly too warm for the room. She was telling the judge that I was unstable, that I had been making erratic financial decisions on behalf of my father's estate for the past 18 months, that my stepfather, Gerald, had tried everything in his power to help me, to guide me, and that I had responded with paranoia and hostility. I did not look at Gerald. I already knew what his face would be doing. My name is Claire Navarro. I'm 31 years old. I hold a CPA license in the state of Texas, and for the past 6 years I have worked as a forensic accountant, which is a very clean way of saying that I find the money people try to hide. I am good at it. I am patient at it, the way a person can be patient when they have been practicing stillness since childhood. My mother died when I was 9. My father, Daniel Navarro, raised me alone in a brick house in San Antonio until I was 14, and then he met Gerald Whitmore at a charity golf tournament in Fredericksburg. And things changed in the slow, quiet way that things change when you are a teenager and not yet paying close attention. Gerald moved in 6 months later. They married the following spring. He was charming in the way that certain men practice being charming, with eye contact and well-timed questions and a habit of remembering small details about your life that made you feel, briefly, like the most important person in the room. He remembered that I liked my coffee with exactly 1 sugar. He remembered the name of my middle school best friend. He showed up to my college graduation with a bouquet of sunflowers because he had heard me mention once, 2 years earlier, that they were my favorite. I told myself I was lucky. I told myself that some people's step-parents were genuinely terrible, and mine was not, and I should be grateful. I was 22 before I started noticing the seams. My father was a civil engineer. He had built a modest but real estate portfolio over 20 years, 4 rental properties in Bexar County, a small commercial unit in New Braunfels, and the family home in Alamo Heights, which had appreciated considerably since he purchased it in 2001. He also had a retirement account, 2 investment accounts, and a life insurance policy with a death benefit of just over $1.8 million. He had a trust. The trust, established in 2009 and amended in 2017, named me as the primary beneficiary and Gerald as co-trustee only in the event that I was under the age of 25 or legally incapacitated. I turned 25 in 2018. The co-trustee clause had expired. I had full control, or I was supposed to. My father was diagnosed with early-onset Parkinson's in 2019. By 2022, the progression had been faster than his neurologist expected. He moved more slowly. He needed help with certain tasks. He tired easily. But his mind was still his. We talked on the phone every Sunday. He still told the same 4 jokes in rotation. He still asked me about my cases, my colleagues, whether I was eating enough, whether I had found anyone worth keeping. What he did not do was tell me that Gerald had been quietly rerouting rental income for 14 months. I found out the way I find most things out. By accident, and then by obsession. It was a Sunday in March of 2023. I was helping my father organize some paperwork during a visit. Tax season, routine, when I pulled a bank statement from a folder that should have contained property management reports. The numbers didn't match what I had seen the previous year. The Bexar County properties were generating about 30% less rental income than they had been. I asked my father about it. He looked at the statement for a long time and then told me that Gerald had mentioned something about maintenance costs, repairs, a difficult tenant situation. He said Gerald was handling it. I nodded. I put the statement back in the folder. I drove home to Austin that evening with a very specific feeling in the back of my throat that I have learned, professionally, to take seriously. I started with what I could access legitimately. My own records as a beneficiary, public property filings, the trust documents I had copies of. Within 2 weeks, I had found 3 things that did not belong. A management fee being paid to an LLC I didn't recognize. A repair invoice for $47,000 on a property that had received no permit filings for that period. A transfer from one of the investment accounts to a joint account that I had not been informed about and had not authorized. I called a colleague of mine named James Okafor, who is a trust litigation attorney in Houston. I told him what I had found. He was quiet for a moment, And then he said, "Claire, how much access do you have to the full account history?" I told him I had some, but not all. He said, "Get all of it." Here's what most people do not understand about financial fraud within a family: it is almost always patient. It does not happen in one large, dramatic theft. It happens in increments so small that each one individually could be explained. A transfer that looks like a bill, a fee that looks like a service, a withdrawal that looks like a repair. The person committing it counts on the fact that grief and trust and love make people terrible auditors. Gerald had been counting on exactly that. Over the next 4 months, I pulled everything I could access, requested records I had a legal right to, and documented every discrepancy I found. I built a spreadsheet that eventually ran to 312 rows. The LLC receiving management fees, Whitmore Property Solutions, had been incorporated by Gerald 11 days after my father's Parkinson's diagnosis. It had no website, no office address, no employees listed. The $47,000 repair had been paid to a contractor whose license number, when checked with the Texas Department of Licensing and Regulation, belonged to a man who had surrendered his license in 2021. The joint account had received 9 severed transfers over 14 months, totaling $233,000. I did not say anything to my father. This is the part that people, in retrospect, will question. Why didn't I tell him? Why didn't I confront Gerald directly? Why didn't I go to the police immediately? Because I have worked enough fraud cases to know what happens when you move too soon. Evidence gets moved, accounts get drained, people get coached on what to say. And because the moment I made this a conflict, it would become a conflict that my father, who loved Gerald, who had chosen Gerald, who needed Gerald's help every day for things I could not provide from 200 miles away, would be caught in the middle of. I needed to be certain. I needed to be complete. I needed to be so far ahead of Gerald's next move that there was no move left to make. So I let it continue. I watched, I documented. I added rows to my spreadsheet. And then my father had a fall in October. He broke his wrist and bruised 2 ribs. He spent 4 days in the hospital and came home with an updated care plan and a physical therapist who visited 3 times a week. He was okay. Shaken, slower, but okay. I drove down the weekend he came home and stayed for 6 days. What I noticed during those 6 days changed the direction of everything. Gerald had arranged, during the hospital stay, for my father's financial power of attorney to be updated. The previous POA had named me as primary agent. The updated version, which Gerald presented to my father to sign the day after he was discharged, when he was still on pain medication, still exhausted, still processing, named Gerald as primary agent with full authority over financial decisions. My father signed it. I found the document in the kitchen drawer on day 3 of my visit. I photographed it. I called James that night from my car in the driveway. James said, "Does your father remember signing it?" I asked my father the next morning carefully, without leading him. He remembered signing something. He thought it was an insurance form. James said, "We need to move." What I did not know yet, what I would not know until the day of the hearing, was that Gerald had also been speaking with a man named Dr. Raymond Chu. Dr. Chu was a psychiatrist in private practice in San Antonio. He treated my father briefly in 2020, for about 4 months, before my father switched to a different provider closer to home. Gerald had apparently maintained a relationship with Dr. Chu. He had apparently been having conversations with Dr. Chu. Chu, about my father's mental state, about my behavior, about concerns that I was isolating my father, pressuring him, taking advantage of his declining health to influence his estate decisions. Gerald had apparently asked Dr. Chu to provide a written assessment. Dr. Chu had provided written assessment. The assessment concluded that based on Gerald's reports and prior patient history, not on any examination, not on any recent evaluation, not on any direct interaction with my father, I demonstrated a pattern of behavior consistent with undue influence over a vulnerable adult. I was not aware of this document's existence until Patricia Holt entered it into evidence at 10:47 on a Tuesday morning in November. I read it once. I set it down. I looked at the wood grain of the table. I breathed. Let me back up 2 weeks. James had filed a petition in probate court to invalidate the updated POA on the grounds of undue influence and lack of capacity at the time of signing. He had also filed a request to freeze the accounts associated with the trust pending a full accounting. Gerald's response had been to retain Patricia Holt, which told me immediately that he had been preparing for this possibility. Nobody retains a trust litigation attorney in 3 days, unless they already had one in mind. The morning of the hearing, Gerald arrived with his sister, a neighbor of my father's named Donna, and a man I did not recognize in a gray suit who sat 2 rows behind the respondent's table and said nothing. My father did not come. He had wanted to. His physical therapist and his neurologist had both said the stress was not advisable, and I had agreed, and he had not fought us on it, which told me more about how tired he was than anything else. I sat at the petitioner's table with James, a yellow legal pad, and a manila folder that I had carried in my laptop bag for 6 weeks like a second heartbeat. Patricia Holt was good. I want to be honest about that. She laid out Gerald's position with precision and sympathy, a devoted partner of 9 years trying to protect a vulnerable man from a daughter who, despite her professional credentials, had allowed her emotions to cloud her judgment. She described Gerald's financial management as careful and conservative. She described my investigation as obsessive and invasive. She described the updated POA as a reasonable, well-considered decision made by a competent adult. And then she entered Dr. Chu's assessment. The judge, the Honorable Margaret Calloway, a woman with short gray hair and the specific kind of stillness that comes from having heard every variety of human desperation for 22 years. Read it without expression. James leaned toward me. We weren't expecting this. I know, I said. Do you want to recess to? No, I said. I'm okay. Keep going. What I did not say was, I was not okay. I was furious in the clean, cold way that I get furious when someone has underestimated me specifically, and that kind of anger is, professionally speaking, an excellent fuel source. Judge Calloway asked Patricia Holt several clarifying questions about Dr. Chu's assessment. When did the evaluation take place? How many sessions? What clinical methodology was used? Patricia Holt's answers were vague in ways that I could see were beginning to register on the judge's face. When it was James's turn, he stood up and said, Your Honor, I'd like to address the assessment submitted by Dr. Raymond Chu. He turned to me. I opened the manila folder and handed him the first document. Dr. Chu's assessment claims to draw on prior patient history and collateral reporting from the petitioner's spouse. It does not describe any direct clinical evaluation of Ms. Navarro, because no such evaluation took place. Dr. Chu has not treated, evaluated, or spoken directly with Ms. Navarro at any point. His assessment is based entirely on secondhand reporting from one interested party. He submitted the document. It was a copy of Dr. Chu's own patient notes, which I had obtained through a records request since my father was the actual patient, showing that Dr. Chu's last interaction with my father had been in April of 2020 and that no evaluation of any family member was documented at any point. Judge Calloway looked at the document. Then she looked at Patricia Holt. Patricia Holt said she would need a moment. James kept going. He submitted the 312-row spreadsheet, condensed into a 20-page financial summary that he had prepared with a CPA colleague who had reviewed my work and signed off on the methodology. He submitted the incorporation records for Whitmore Property Solutions. He submitted the contractor license verification showing the repair invoice had been paid to an unlicensed individual. He submitted bank records showing the $233,000 in transfers. And then he said, Your Honor, may I direct your attention to page 14? Page 14 contained records for an account at a credit union in New Braunfels that had not appeared in any of Gerald's prior financial disclosures to the court. The account had been opened in September of 2022, 3 months after my father's Parkinson's diagnosis. It had received deposits consistent in timing and amount with the missing rental income. The account was held jointly by Gerald Whitmore and a woman named Sandra Whitmore. Sandra Whitmore was Gerald's ex-wife. They had divorced in 2015. I had found this account 6 weeks ago when I was cross-referencing Gerald's prior tax filings with credit union branch locations. I had told James. I had waited. I had not said a word to anyone. I looked at Gerald for the first time since the hearing began. He was looking at the table. Judge Calloway called a brief recess. She came back 12 minutes later with the specific expression of a person who has organized their thoughts into a formation. She said that she found the financial evidence presented by the petitioner to be detailed, well-documented, and credible. She said that the POA signed in October would be suspended pending a full competency evaluation of my father conducted by an independent neurologist appointed by the court. She said that all trust assets and associated accounts would remain frozen pending a complete forensic audit. and that the court would appoint an independent trustee to oversee distributions during that period. She said that the assessment submitted by Dr. Burzat, Raymond Shu, would be stricken from the record, as it did not meet the evidentiary standard for a clinical evaluation and appeared to have been produced without direct examination of the subject. She looked at Patricia Holt and said, "Counsel, I would strongly advise your client to be forthcoming in the audit process. The financial irregularities documented here are significant enough to warrant referral to the district attorney's office, and cooperation will be a relevant factor." Then she looked at Gerald. She said, "Mr. Whitmore, this court takes the financial exploitation of vulnerable adults very seriously. I hope that is clear to you today." She removed her glasses and set them on the bench and looked at him for a long, flat moment. Gerald nodded. He looked smaller than I had ever seen him look. I sat in my car in the parking garage for a while after. I did not cry. I felt too clean for crying, like a room after all the furniture has been taken out. I called my father. He answered on the second ring. I told him that it had gone well. I told him the accounts were protected. I told him that I was going to make sure everything was okay. He was quiet for a moment, and then he said, "I'm sorry, baby. I'm sorry I didn't see it." I said, "You trusted someone you loved. That's not a mistake. That's just being human." He made a small sound that wasn't quite a laugh. I drove back to Austin with the windows down. The forensic audit took 3 months. The final number was $417,000. The 233 indirect transfers, plus the routed rental income, plus a life insurance premium that had been redirected. Gerald's attorney negotiated a civil settlement rather than face criminal prosecution. The money was returned to the trust in 2 installments. Dr. Raymond Shu was reported to the Texas Medical Board by James on my behalf. An investigation was opened. I do not know yet what the outcome will be. What I know is that a psychiatrist who has not examined someone cannot, ethically, submit a clinical assessment of their mental state to a court of law. I know this. The medical board knows this now. Dr. Chu knows this now. Dr. Chu knows this now. Gerald and my father divorced in February. My father told me it was the easiest decision he had made in years, and the hardest morning after. I moved to San Antonio in the spring, not to watch over my father. He does not need watching over. He needs company, which is different. I am working remotely now, taking cases I find interesting, spending Sundays at the house on Alamo Heights where I grew up. We watch old movies. He tells the same 4 jokes. I laugh at them every time, not because they are funny, but because they mean he is still there to tell them. The manila folder lives in my file cabinet now, behind a tab marked "Closed." I kept the spreadsheet. You always keep the work. If you have ever sat in a room and felt like the truth was so obvious you could reach out and hold it, while everyone around you watched someone lie directly to their face and nodded, I want you to know that patience is not the same as doing nothing. Sometimes the most powerful thing you can do is be so prepared that by the time you speak, there is nothing left to argue with. I played to the evidence. That is the only play that wins.